Welcome to Module 9, and this will be one of the longer modules, but this is the professional credit dispute and enforcement process, right? The four-round dispute escalation framework. And the objective is to teach you how to dispute inaccuracies while creating a documented legal paper trail. And every dispute should be prepared in a way that preserves evidence if the case has to escalate to regulatory complaints or litigation. But this is the setup to really be able to get these accounts removed off of your credit report. So pay close attention. So the documentation standards before sending any disputes, what you want to do is follow best practices for documentation. So dispute letter requirements, right? Each dispute package that you send off to the credit bureaus, your lenders, collection companies, etc., it needs to be signed, right, and notarized. You want to get them notarized. That's recommended, but it's best practice. You want to attach a copy of your ID and proof of address, like a recent utility bill or bank statement. Make sure that when you take a picture of your ID, that it covers the full four corners of the image. And also your utility bill or bank statement, you only have to send the first page, right? A lot of people will attach the full bank statement. It's like 10, 20 pages, but you only need the first page that shows your information and address and the sender's information and address. Then you want to send any supporting documentation if it's available. So why notarization is recommended? Notarizing your dispute letters helps establish identity verification, legitimacy of the dispute, and stronger evidence if litigation occurs, right? It turns your dispute letter from a simple dispute letter into a legally binding document, right? It also prevents credit bureaus from claiming that the dispute was not submitted by you, the consumer, and somebody else, right? The identity cannot be verified or something like that. So the certified mail requirement. You also want to send off these dispute letters once you get them notarized. You attach your documents. You want to send them via certified mail and use a return receipt. What this does is it provides proof that the letter was actually mailed by you, proof that the bureau actually received the letter or the dispute letter, and there's a timestamp documentation for legal enforcement. You don't want to skip any of these steps. You want to separate your dispute processing, your dispute letters from the 10,000 other disputes that's coming into the credit bureaus every single day. Why this matters? If disputes escalate, right, the certified mail receipts again prove when the bureaus actually received the disputes and that the bureaus had the legally required 30-day investigation window, right? This documentation becomes critical evidence for things like CFPB complaints, attorney general complaints, and any lawsuits under the FCRA. So round one is the factual dispute method, right? The objective is to challenge inaccurate reporting using specific factual errors, right? We're not just claiming, we don't owe the account or that the account doesn't belong to me. None of that stuff really works, right? And the legal basis for this is under the FCRA Section 611, which is your right to dispute inaccurate information. So you want to dispute issues like the incorrect payment history, incorrect balances, any incorrect dates, any incorrect account statuses, and accounts that might belong to someone else. So the process is you want to prepare your dispute letter so that it clearly identifies the account, it explains the factual error, and it requests the investigation and correction. You can also include things like you have reason to believe that the source of the information is unreliable and that you suffered some sort of financial harm. Maybe you didn't get a credit limit increase, you were denied a mortgage, auto loan application, credit card. All of those things included in the letters actually help. And there is a dispute letter library included in this course that you guys can use for reference, or you can edit and send off yourself. So again, the dispute package should include the notarized dispute letter, the copy of your ID, the proof of address, and then you want to send it certified mail with the return receipt. Now, the expected timeline. So the credit bureaus, they have to investigate any disputes that you send within 30 days from the date that the dispute is received. And this is why you want to create that timestamp by sending it certified with the return receipt, right? And then possible results is that the account is either corrected. Hopefully that's just late payments on a current account. We could get those corrected and updated to positive. Hopefully the account is just deleted if it's that charge off, collection, repo, bankruptcy, etc. Or they might verify the account as accurate. But if they verify it as accurate, then we want to move on to the second round of disputes in this process. So when it comes to round two, what we want to do is what's called a method of verification. And again, with all of this disputing, we're leveraging the federal laws under the FCRA, right? And the objective is to challenge the adequacy of the Bureau's investigation process. Again, they use a system called eOscar, which is automated. It's just two computer systems communicating between the bureaus and the lenders. And there's no real investigation that really happens, which under the Fair Credit Reporting Act, once you've kind of escalated the dispute, is not reasonable enough for them to continue reporting that inaccurate information. And the legal basis for this is found under FCRA section 611A6B3. And you guys could check, some of this stuff. When we have our classes, we'll be going over a lot of this. And consumers have the right to request this method of verification under this specific part of the law to verify disputed information. So what you want to request, right, when you send off that method of verification letter, you want to request from the Bureau and have the person who verified the account, the address of the furnisher, the method used to verify the information, and any documentation that was relied upon in the investigation process. And a lot of times they don't forward any information that you include, which again helps you if you need to escalate this situation or the disputes. So why this step matters? Again, most investigations occur through what's called the eOscar system, which is an automated process where the Bureau simply transmit dispute codes to the furnishers. Again, there's no real person that's involved, no real discretion. And if no real investigation occurred, this can create potential FCRA violations. And it happens every single time because that's all that they use. It costs them too much to hire, a staff to really be able to investigate these things properly. But they know this. So now, round three, if they come back and they verify things again, then we want to use regulatory escalation. And the objective here is to apply regulatory pressure if inaccuracies remain on your credit reports. So what you're going to do is you're going to escalate that dispute through the Consumer Financial Protection Bureau, CFPB. You want to file the CFPB complaint, and you want to make sure that you have, that paper trail of the disputes that you sent, copies of your credit reports, the certified mail slip, the return receipt. All of those things are going to help you when you submit these things to get the CFPB involved to help remove it. You also want to escalate it to the Bureau legal departments, right? You're going to find that, we've included the actual legal department addresses as well. So once you get to this round, you can start sending your letters there instead of through the regular, addresses that the credit bureaus have where they're using that eOscar system, right? You also want to escalate it to the original lender and the original furnisher of that account. You want to include also a state attorney general complaint. So you want to file a complaint with your attorney general and also file with the Federal Trade Commission or the FTC, right? By incorporating these government agencies and escalating these disputes, this is where the real results happen if those accounts remain on your credit report. And I'm telling you guys, this makes all the difference. So the complaint documentation, what you want to include in any complaint that you're sending to the Attorney General, CFPB, FTC, even to the original lenders, and to those legal departments for the credit bureaus is copies of the disputes, the certified mail receipts, the return receipt confirmations, and copies of your credit reports showing the inaccurate reporting. So you want to create a dispute log. All of the templates for these things are going to be found in the course as well so that you can log your disputes, you can keep track of your disputes, et cetera, et cetera. And then when we go through some of the classes, I'll give you guys some software that you can use to kind of help aid you in this process. Maybe you want to start doing this for other people and you just need a more effective system. You should also send escalation letters again to Experian's legal department, Equifax's legal department, and TransUnion's legal department. Again, we don't want to send it to the address where they're using eOscar. We want to get some real eyes, some real people that can use discretion and see, hey, well, this consumer has enough against us to really win a case. And this is what's going to help force them to make those changes and deletions if you get this far in the dispute process. So again, these letters are going to outline previous dispute attempts, failure to correct any inaccurate reporting, and evidence supporting your disputes. So Experian's legal department address is on the screen. It's Experian Information Systems Incorporated, legal department, 475 Anton Boulevard, Costa Mesa, California, 92626. And this address is commonly used for notice of FCRA violations, notices of intent to sue, which is the type of letter that we're going to be sending on that round, attorney correspondences, and any escalated disputes after normal investigations. Same thing with Equifax. Their legal department Address is Equifax Information Systems LLC, Office of Consumer Affairs / Legal Department, 1550 Peachtree Street, Northwest, Atlanta, Georgia, 30309. And again, this address is used for legal escalations, pre-litigation dispute notices, notices of intent to sue, attorney communications, and compliance complaints. TransUnion, their legal department address is TransUnion LLC, legal department / consumer relations, 555 West Adams Street, Chicago, Illinois, 60661. And this department, they handle those legal notices, notice of intent to sue, FCRA dispute escalations, attorney correspondences, and compliance inquiries. So now when it comes to furnisher disputes, so in addition to contacting the credit bureaus, you also want to dispute the reporting directly with the lender or the entity furnishing the information. So this step is supported by the Fair Credit Reporting Act under Section 623, responsibility of furnishers. But you first have to start the dispute process with the credit bureaus. You can't just go straight to the furnisher. I wish we could just pull your credit report, and if you see any inaccuracies, you could just sue the credit bureaus, but you have to go through these dispute phases. So under this section, data furnishers must conduct an investigation when disputes are received. They have to review any relevant information provided by you, the consumer, and they have to correct inaccurate reporting when any of those errors are identified. Now, the notice of intent to sue for legal escalation. So as part of the escalation process, you might want to send what's called a notice of intent to sue. There will be a sample letter included in the course for you, but this is going to help you, escalate that dispute, and you're going to send it to the legal departments of the credit bureaus. So this notice is what informs the bureaus that you, the consumer, believe that your rights may have been violated, and that legal action may be considered if the issue is not resolved. So again, we just want to put that pressure on them. So the purpose of this furnisher disputes is that disputing directly with the furnisher ensures that the entity supplying that information to the credit bureaus is aware of the dispute, because they have to be put on notice too. Because after that, if they continue to do so, now you got legal grounds to sue them, right? And since the furnishers are the original source of the account data, they're responsible for ensuring that that information is reported to the credit bureaus accurately. So what the notice of intent to sue should outline are things like this, right? Identification of the disputed accounts, a summary of your prior dispute attempts, documentation showing inaccurate reporting, and an explanation of why you believe that the reporting violates consumer laws, right? And the notice may also request that the bureaus correct or remove the inaccurate information within a specified time frame, right? So documentation that you want to include, again, when sending a notice of intent to sue, you want to include copies of your dispute letters, copies of credit reports showing the disputed items, those certified mail receipts demonstrating prior correspondence, the return receipt, and any supporting account documentation. And these materials help demonstrate that you have made multiple attempts to resolve the issue, but it never happened. Now, how to file your CFPB complaint, right? The CFPB is the Consumer Financial Protection Bureau, and they just allow you to file your complaints online. So step one is you want to submit that complaint online. You can file it through the CFPB complaint portal, and the complaint typically is going to ask for the company involved, the type of financial issue, a description of the dispute, and any supporting documentation. And this is why, again, keeping a record of the dispute letters, your credit reports, certified slips, return receipts, all of those things is important in each step of the process. So now step two is you want to provide that supporting evidence. So you want to attach those dispute letters, again, credit report screenshots showing the errors and any responses received from the credit bureaus, right? And when you sending these screenshots or you're including your credit report, you want to use your actual TransUnion, Equifax, or Experian report. Do not take screenshots of Identity IQ, MyScore IQ, MyFreeScore Now, any of the third-party credit monitoring services that you may use, because those are not actual credit bureau reports. They're a rendition or an interpretation of your credit report displayed in a different form. So they don't work in court. You need your actual credit reports. And again, you can go to annualcreditreport.com. They give you a free one every week. But this helps those regulators understand the dispute and evaluate your issues. So step three is the company response. So after the complaint is submitted, the CFPB is going to forward that complaint to that actual company. The company is going to be asked to review the issue, and then the company typically will provide a response within a few weeks or even a few days. So you're going to be able to review the company's response through the complaint portal through the CFPB once you set up that account and file your complaint. Now, how to file a complaint with the FTC. So the the Federal Trade Commission, they collect complaints about deceptive and unfair business practices. And this is why we want to leverage them, because if you get to the point where you're this deep into the rounds of disputing, now it's just unfair and deceptive on the part of the credit bureaus and your original furnisher or lender. So FTC complaints help those regulators monitor patterns of consumer issues across different industries. So the first step is to submit the complaint. You want to go file that complaint through the FTC complaint reporting system. And again, you're just going to go to federation.com or just Google FTC. Make sure you click the right link, and it'll take you directly to the portal, right? And the form typically is going to ask for the company name, the nature of the complaint, and details of the situation. Step 2 is to provide that detailed explanation. So what you want to do is clearly explain the inaccurate credit reporting, the disputes that you already submitted, and the outcomes of previous investigations that didn't result in anything. Nothing was corrected, nothing was updated. They just kept verifying it, right? And then, of course, you want to include supporting documentation. Step 3 is to review the complaint, right? So the FTC doesn't usually resolve individual disputes directly. Instead, complaints are entered into a national database used by those regulators to identify those potential patterns of misconduct. But again, it still puts that pressure on that particular credit bureau or your lender, because they don't want to end up in that database, right? Now, how to file your complaint with your state attorney general. So each state maintains an attorney general's office that's responsible for enforcing consumer protection laws within that state. So you can file that complaint with your attorney general, their consumer protection division. And that's what you're going to do. So step 1 is you want to locate the state complaint form. You're just going to go online, go to state attorney general section, right? And then you're just going to find where you can submit your complaint for your particular state. And most attorney general offices provide that complaint form through their official websites. They're typically going to request the consumer contact information, your information, the company that was involved, details of the dispute, and that supporting documentation. Step 2 is to submit the supporting evidence. So what you're going to include, again, is copies of your dispute letters, credit reporting documentation, the certified slip, the return receipt, and responses received from the credit bureaus or your lender. And providing documentation is going to help that office evaluate that complaint and up that legal pressure on the bureaus and your lenders, right? Now, the review of the attorney general complaint, right? So what happens is the attorney general's office, they may contact the company that's involved, right? The credit bureau or your lender. They're going to request additional information and refer the complaint to another regulatory agency. And some offices may facilitate communication between you and the company as well, right? So now round 4 is the federal litigation. So if after 3 rounds they haven't done anything, now we want to go enforce it through the courts. Now you want to file that lawsuit against the credit bureaus and your lenders, right? So if inaccurate credit reporting remains on your credit report after round 1, factual dispute, after round 2, method of verification, and round 3, regulatory escalation, then the final escalation step is legal enforcement through the federal court. And at this stage, you want to assert that the credit bureau or your furnisher or your furnisher has failed to comply with federal consumer protection laws, most commonly the Fair Credit Reporting Act and the Fair Debt Collection Practices Act. And a lawsuit can be filed in that federal court in your jurisdiction or in your county when you believe that the company failed to either conduct that reasonable investigation, correct that inaccurate reporting, or comply with the dispute obligations under the law. So when litigation is appropriate. So you should only consider litigation after documenting that the inaccurate information was disputed multiple times, right? The credit bureaus were given the required investigation period and the inaccurate reporting continues to appear. And to strengthen that litigation process, you want to also be able to prove that you were harmed financially as a result of the credit bureaus not doing what they were supposed to do, not complying. So again, it sounds counterintuitive, but at that point, you may want to go apply for something like a mortgage, right, and get denied, right? That's the most important one. If you apply for a mortgage and get denied, you can also apply for a car loan, get denied, apply for a credit card, get denied, or a limit increase, get denied. Things like that prove that information is still harming your ability to move forward financially. That is another important step in the process. And at this point, the dispute history becomes evidence of potential non-compliance, and that's what you want. So some common legal claims in credit reporting lawsuits. So the most common claims in credit reporting litigation involves violation of the FCRA, right? Typical allegations include failure to conduct a reasonable investigation under Section 611, where credit bureaus must investigate the disputed information and review the evidence provided by you. And if the investigation was superficial or automated without review of documentation, it can be challenged, which happens every single time. This is why this is the perfect alley-oop and slam dunk for you if you follow this dispute process for the 4 rounds and you get to this point, right? It's foolproof, guys. Because we're leveraging the law, you know what I'm saying? But you have to not skip steps. You can't shortcut this process. You need to document everything. And this is what's going to get you the long lasting results where these accounts are not going to pop back up. You know, you'll be able to get compensation and you'll be able to get those accounts deleted, right? So reporting inaccurate information under 607 of the Fair Credit Reporting Act. Again, the bureaus have to follow procedures to assure maximum possible accuracy. And this is why we use this method to get accounts deleted from your credit report or escalate the dispute process to the courts, right? Because if things are still not accurate on your credit report and you've proven that through the dispute process, then again, it's a slam dunk every time. And failure to maintain accurate reporting procedures is what leads to liability on behalf of the credit bureaus or your furnisher, right? So furnisher investigation violations, FCRA section 623 information must investigate the disputes forwarded by the credit bureaus, and failure to correct inaccurate information after notice is what leads to liability. So step one, again, organize the evidence file. Before filing a lawsuit, you need to organize your complete dispute record, right? Your file needs to include copies of all dispute letters, certified mail receipts, return receipt confirmations, responses from the bureaus, credit reports showing inaccurate reporting, regulatory complaints that were filed, and any evidence that you were harmed financially by getting denied new credit, right? And this documentation demonstrates the timeline of events and the dispute history. We'll review in some of the classes in this course certain consumer case laws where consumers were successful against filing, lawsuits against the credit bureaus, and then you'll see where all of this makes perfect sense, right? So step two is just identifying a proper court. So FCRA lawsuits are commonly filed in federal district courts because the law is a federal statute. And then, federal courts, they have jurisdiction over cases involving violations of federal consumer protection laws. But you can also file a small claims court. I don't recommend that. I recommend just going the federal way, right? And the lawsuit is typically filed in a federal district court where where you reside, the inaccurate reporting occurred, or the company conducts business, but you could do it where you reside. Then step three is just drafting your federal complaint, right? The lawsuit begins with the legal document called a complaint. Included in this course is some samples of drafted federal complaints that you can use to help yourself. And we'll review some of that in the classes. So the complaint outlines the parties involved, the factual background, the alleged legal violation, and the damages that are requested. So the typical structure of an FCRA complaint in federal court, right? Again, you want to identify the court and the parties, and the example is on the screen: United States District Court, the name, plaintiff you versus either Experian Information Systems, Equifax, TransUnion, whoever the furnisher is, and those would be the defendants, right? You're the plaintiff. So again, the jurisdiction explains, why the federal court has authority to hear that case, and this section usually references federal jurisdiction under the FCRA. So the factual allegations, right? This is the section where it's going to explain when the inaccurate reporting occurred, when disputes were submitted, how the bureaus responded, and how the inaccuracies remained on the credit report. And then the factual section often includes a timeline of those disputes. Now, the legal claims, right? So the complaint then is going to identify the specific legal violation. So some examples are failure to conduct a reasonable investigation, failure to maintain accurate reporting procedures, and failure to correct the inaccurate information. And again, once we review some of these cases, you'll see exactly why this all makes sense. Now, the damages that's going to be requested. So you could request several forms of relief, and possible damages may include actual damages, which is financial harm caused by inaccurate reporting, which is the strongest; statutory damages, which are allowed under certain circumstances; punitive damages for willful violations; and then, of course, attorney fees or legal costs associated with the case. But you want to really shoot for actual damages, statutory or punitive. Actual, again, is where you suffer some sort of financial harm by being denied a line of credit, mortgage loan, et cetera, et cetera. So step 6 is the discovery phase in this process. So if the case proceeds, right, the parties are going to enter into what's called the discovery phase. And during that phase, both sides will request internal investigation records, dispute handling procedures, communications related to the account, and documentation supporting the reporting. And this phase is what allows the parties to examine the evidence. And this is why you have to keep a good record of each round of disputes, and why this is why I'm teaching you to dispute away. Step 7 is the settlement or the trial. So most credit reporting lawsuits are resolved through settlement negotiations, and you don't even have to go to trial. So they'll enter a summary judgment because, again, you have all the evidence against the credit bureaus. And what they don't want is this to go to trial and then end up on the public record, right? So what they'll do is they'll settle with you, right? But if the case does not settle, then it may proceed to a trial where the court is going to determine whether the violation actually occurred. So key takeaway: effective credit repair follows a 4-step escalation process that moves from basic disputes to legal enforcement if inaccurate reporting is not corrected. Round 1 is your factual dispute, right, where you're going to dispute specific inaccuracies with the credit bureaus under the FCRA, requesting an investigation and correction of the reporting. Round 2 is your method of verification. If the account is verified, you want to request that the bureaus provide you with their method of verification to determine how the investigation was actually conducted and which furnisher confirmed that information. Round 3 is then your regulatory escalation, right? So if inaccuracies remain after that, then you want to escalate the disputes by filing complaints with the Consumer Financial Protection Bureau, the FTC or Fair Trade Commission, your state's attorney general, while also sending escalation letters or a notice of intent to sue to the legal departments of Experian, Equifax, and TransUnion, and also your actual furnisher. You want to do the furnisher disputes as well. And then round 4 is the federal litigation. Again, if after round 3, they're still not trying to bend or correct anything, that's when we want to start federal litigation. So again, if the reporting remains inaccurate, that final step is filing a federal lawsuit alleging violations of consumer protection laws, right? And the key to this process is maintaining a complete paper trail of your disputes, documentation, and responses to support enforcement if legal action becomes necessary, right? And that's how you clean up your credit, guys.